Lawyers of Reddit, what's the most ridiculous argument you've heard in court? Story 1. Lawer who is not practicing in court, but when I was in college doing my bachelor's degree, criminal law was part of the curriculum, and this included spending a couple of days observing criminal trials. The things you witness. Anyway, at the start of one of these trials, a guy with the greasiest mullet enters the room. Thin, tall, disproportionately sized limbs, tattoos all over. I swear the way he sat before the judge. The only thing that was missing was a beer in his hand and a chicken under his arm. Now, this guy chose not to have a lawyer represent him as he's a regular and spends short periods of time in jail or doing community service pretty much every month anyway. Real problem case, substances, alcoholism, etc. But still, he comes across as a really sympathetic dude and has a really entertaining way of telling a story while keeping a straight face and not realizing how funny he is. He knows he's getting fined, and a couple of hours of cutting weeds as community service to keep our Dutch streets nice and tidy, but tries to win the sympathies of the judge to decrease his sentence. This man's dog was sent to a dog shelter when they found it malnourished a couple of weeks before when they brought him in for dealing. Real sad, but also the reason he's standing trial. The guy got high as a kite and tipsy as an Irishman on this St. Patrick's, and while completely drugged out of his mind, decided to get his dog back from the shelter because he really missed his girl. The judge asks him if it's correct that he broke the lock in some of the camera equipment on site of the dog shelter, and he confirms. You could really tell from his passionate account of the progression of the evening that he did all this out of pure love, as his dog, according to him, was the only thing that pulled him through all of his rough patches with his girlfriend and his substances problem. So the judge orders camera footage to be shown to confirm that it is the suspect, and he confirms. On it, he is seen stumbling about and wrenching one of the dog enclosures open and hugging a German Shepherd. At this point, everyone is touched by seeing this guy be so emotional on the camera footage with the dog, hugging it, petting it, and playing with it, and you can see the judge really get into it as well. Anyway, so this guy continues with his story and tells about how he took the dog to his car and went home never feeling happier in his life, and ends his account with the driest delivery of, "Needless to say, I was fudge surprised when I woke up the next day and there was a German Shepherd in my room instead of a Staffordshire Terrier." Everyone just broke out in laughter. He didn't get what was funny. Turns out the dude stole the wrong dog. Judge sentenced him to 50 hours of community service and 3,000 or so repairs for the broken doors and camera equipment. TLDR guy tries to win sympathies of judge with passionate account of how he broke into a dog shelter and steal his dog back from animal services. Steals the wrong dog. Story 2. As a corporate lawyer, the most ridiculous argument I come across almost monthly is as follows. Fortune 500 company signs a garbage contract and is going to lose a lot of money due to the plain language of that contract. Fortune 500 company argues unconscionability, specifically that said company was not sophisticated enough to read the contract and no reasonable person would ever agree to the term or terms in dispute. In some multi-billion-dollar firms claiming they're incapable of reading contracts. Story 3. Law student, former professor story. Defendant busted for possession of narcotics. They were in the pocket of his leather jacket. He argues the search was illegal because, with his buttery smooth leather jacket, there's no way the officer would have felt the substances in his pocket during a pat-down, so he shouldn't have reached in the pocket to find the substances in the first place. Judge asked if the jacket is the one he was currently wearing in court. It was. Judge asks to feel this jacket in the pockets. Defendant hands it to the bailiff. Judge finds more substances in the pocket. Needless to say, it didn't go well for him. Story 4. I was a juror, but this was a hell of a defense. Defendant ran through a red light and crossed against traffic in front of an officer. She was over twice the limit. It wasn't her fault. She had a cut on her arm that her dog licked. The yeast from the dog's saliva entered her bloodstream and converted her blood sugar into adult beverage. Story 5. An opposing attorney the other day said I should not cross-examine his witness at a preliminary hearing because it would only hone the witness's testifying skills to be cross-examined at trial. I laughed out loud. Story 6. Oh geez, where do I start? I mean, I could tell plenty of these about my own clients, but I like this one. A lady has an injury comp case. It's for her upper back and, of course, complex regional pain syndrome. She decides she needs the insurance company to pay for a special mattress for her, like a 6,000 memory foam. with heat and massage and 1,000 other features. And not just a twin, she needs a California king because, of course, her layabout unemployed boyfriend needs to sleep there too. We spend months litigating this darn thing. Finally, she buys it herself, and my client agrees to give her $1,500 just to be done with it. The judge takes myself and opposing counsel aside and says he's gonna motherfuck us if we ever say the word mattress in his court again after wasting all this time. It was that ridiculous. Not 3 months go by and the case comes on for another hearing. After exhausting all the chiropractic care allowed under the law, her doctor was seeking a variance to get some additional chiropractic. We get to court, and I'm arguing it should be denied, etc. Judge turns to her and says, "Ma'am, why do you feel you need more chiropractic care?" She pauses for a minute, then says, "I'm having a lot of trouble sleeping on my mattress. I think I saw smoke coming out of his ears." Story 7. In family court, hearing a motion for entry of a restraining order for an abusive husband. Husband's lawyer argues that in a marriage, there is implied consent for a certain amount of abusive violence. Story 8. I have a brief encounter. Personal injury prospect. Old lady slipped, fell on an icy driveway, which was not salted or maintained, so she wanted to sue for damages. After hearing the story, turns out the lady fell on her own driveway, which she did not salt maintain. She was wanting to sue herself. Story 9. Had a pro se litigant argue that she didn't owe the credit card company because Jesus. The basic argument was that debt is a sin, or maybe not paying the debt was a sin, and Jesus died for all of our sins. Therefore, Jesus died to pay off her debt. Brilliant. Story 10. I was in the public gallery for this while studying law. I was not the lawyer. Leeds Crown Court back in the early 90s. 75 IO foreign. Yes, this is important. Man was facing a preliminary hearing at relating to charges that he had intimacy touched a 13-year relative. His barrister made a successful plea for bail based upon this man being an established pillar of the immigrant community, and the judge asked the old man if he had anything to say before he was bailed until the next hearing in a month. He made 2 comments. 1, she was wearing very, very tight shorts, and I should not be held responsible because no real man could resist see something like that. The judge reminded this was a preliminary hearing, not a trial, so he should wait until the trial to argue his case, especially statements that are far from exculpatory and are better suited to mitigation. 2, I cannot reappear in a month because I am flying back to my home country tomorrow and will not be coming back. The barrister appeared to be just as surprised as the rest of us. The judge ordered the defendant's passport seized, and he was remanded in custody until his trial. Story 11. I heard this story from a cop. A man was arrested for charges of assault and violation. This was in Oklahoma and I'm in Texas, so I'm not sure what the offense is called there. Anyway, he was being accused of shoving the women on the ground where there was some debris and she sustained injuries, hence the assault, and then accused of violently raping her. During court, the injuries were mentioned. The man representing himself objects. Allegedly, his exact words were, "So how do you know that the injuries were from when I pushed her down and not from when I violated her?" From what I heard, the judge's face was priceless. Story 12. Girlfriend is a Reddit lurker, posting on her behalf. This is a story that my grandpa always tells, so some of the details are fuzzy, but this is the gist of it. My grandpa was a public defender, and this was a defense he used for one of his clients, who was being accused of attempting to break into a car. How it happened. Man 1 is sitting in his house, and he looks out the window and sees Man 2 next to a car parked in the street. Man 2 is out there fiddling with the car door for like 10 minutes, and so Man 1 realizes he's trying to break into the car and calls the cops. Man 2 runs, and eventually Man 3, my grandpa's client, is picked up nearby because he matched the description of Man 2. So, my grandpa is meeting with his client and telling him what he's accused of. Client asks, "Wait, what kind of car was it?" Grandpa tells him. Client says, "I can prove that it wasn't me." Grandpa, "How?" Client, "When you said the guy was out there for 10 minutes, I can break into that car in less than 20 seconds. Grandpa, "Prove it." So he finds one of whatever kind of car it was, and the client proceeds to pick the lock in 12 seconds. Grandpa gets the judge out there, and the client does it again for the judge, who makes him do it one more time and then dismisses the case. Story 13. Several years ago, I was doing a civil trial, personal injury, defending a woman who, allegedly, hit a bus matron with her car. We had offered to concede liability and just try damages. In other words, the jury wouldn't hear the circumstances of how the injury happened, just that we agreed my client caused the injury, and they would only decide the amount of damages, We had evidence that the plaintiff was significantly exaggerating her injuries. The plaintiff's attorney refused to agree to our concession, thinking that if the jury heard the circumstances, they'd want to give even more money to punish my client. So we went to trial on liability. The plaintiff called one witness, her client, who testified that an older woman in a green car hit her. They rested and I moved for a dismissal for failure to prove a case. There was literally no evidence connecting my client to this incident, just an older woman in a green car. The plaintiff never bothered to call my client to the stand. The attorney told the judge that the bus driver had written down my client's license plate and gave it to the police. They never bothered trying to find the bus driver. The attorney asked if she could just put the police report in, and I objected that it was hearsay. The attorney then actually said, "Please, just let me put this in. I haven't had work in a while, and I got retained by a firm to try this case. I really need to win this." Of course, I didn't agree, and the judge dismissed the case. I felt a little bad for her, but that was maybe the worst presentation of a case I ever saw. I spoke with the jury afterwards, and they all said they disliked the plaintiff, didn't believe a word she said, and likely would have found in my favor anyway. Moral of the story, be prepared in court. Story 14, recovering small business a BK attorney here, was in bankruptcy court on a motion of my own when a very young attorney gets up to argue his position. His request was denied in pre-hearing disposition. Young attorney, YA. Your Honor, I believe your reading of the 3 cases you have cited is incorrect. Bankruptcy court judge, BKG. You think that, do you? YA, yes, Your Honor. I don't think the bankruptcy appellate panel believed these cases would be used in this fashion, and I think you are misreading the author's scope. BKJ, okay. Tell me, as those are BAP opinions, who wrote those opinions? YA, I'm not sure, Your Honor. I didn't check. BKJ, in the future you may want to check those sorts of things. All 3 cases were authored by the judge you just told didn't understand his own writing. Court audience, mostly attorneys. Collective gasp, YA, blank stare, BKJ, facepalm, Jesus son, I wrote those opinions, YA. Oh, well I still think they're wrong. BKJ, request denied, get the hell out of my courtroom. It was, quite possibly, the most awkward type of walk of shame I've ever seen as he gathered his things and left. Story 15. Not a lawyer, but I was in traffic court and a cab driver had got a ticket for running a red. He argued that it was really difficult to see because the sun was rising, morning, right where the light was. He was traveling west. Story 16. Lawyer here. During an order of protection, hearing the 6'3" muscular tattooed idiot told the judge that my 5'1" female client deserved the black eye he gave her because she wouldn't stop running her mouth. He actually expected the judge to be sympathetic or something. The second he admitted to hitting her, the judge cut him off and said, order of protection granted, next case. Answer, one of my best friend's neighbors started dating a married woman. We all agree that was shoot. Well, the woman's husband came to the neighbor's apartment and started banging on the door and hurling insults and threats. My buddy wound up having to go out there and tell him to shut the fudge up. Neighbor had called my friend for help while he was waiting for the police to show up. Neighbor rightfully filed for a restraining order. Passing threats aren't cool, yo. And had brought my friend as a witness to the event. Well, the judge was more than happy to hear my friend's testimony since he works in federal corrections. The worst part is the dumb jerk hurling passing threats was a state sheriff. Don't you think he should have known better? You also can't carry a weapon if you have a restraining order against you, so this guy fudged his job up plenty too. Stupidity knows no bounds. Story 17. Not in court, but a conversation in my office. It doesn't matter if you were sober or not. You jumped out of a 3rd-story window with a beer bottle and threw it at a cop. The jury's going to think you were tipsy. Also, I think you were tipsy. Story 18. Edit. Actual lawyer here. Hands down the most ridiculous argument I've ever heard was a constitutionalist, pro se defendant, trying to explain why the court lacked jurisdiction over him. I was prepared for the standard arguments about freemen on the land, non-corporate natural person, admiralty court, etc. But this one was different. This particular defendant was part of a Jehovah's Witness compound and happened to be Marshallese American, i.e., he was black. After the court patiently explained to him that it has jurisdiction over all persons in the county, the defendant promptly piped up that, under the Dred Scott decision, he wasn't a person and the court had no jurisdiction. Answer, posting for the benefit of those that do not know the case, Dred Scott versus Sanford, their 1857. The case was a landmark decision by the United States Supreme Court on U.S. labor law and constitutional law. It held that a Negro whose ancestors were imported into the U.S. and sold as slaves, whether enslaved or free, could not be an American citizen and therefore had no standing to sue in federal court. Persons of African descent cannot be, nor were ever intended to be, citizens under the U.S. Constitution. Story 19. Prosecutor here had a case where a man violated his 6-year-old daughter because she wore suggestive clothing and seemed to be asking for it. He tried to argue that, girls are just intimacy active at a younger age now. I remember thinking, what would Dexter do? Anyway, man got convicted and is now serving 2 life sentences plus 100 years. Edit. The reason for that sentence is that he will not be eligible for parole. He was convicted of 2 counts of violation, 2 counts of forbidden topic, and 2 counts of aggravated child molestation. In my jurisdiction, you're eligible for parole on a life sentence after 30 years. Life and life without parole are 2 different sentences. Here, he was not eligible for life without parole. So in theory at least, yes, he could serve 2 consecutive life sentences, which would be 60 years, and then parole. Now, however, we are certain he never draws another breath as a free man. I've done several of these cases, and to me, they're much harder than takedown cases because of the pressure. In this case, the man had no other complaints than this as a father. So if I lost, the poor girl goes back to rapist dad. Story 20, not so much ridiculous as ghastly, but a man accused of raping his own daughter saying he couldn't have done so because he had a 9-inch cock, and it would have caused her damage. And that the physical signs of intimacy activity that she did exhibit were because she'd been screwing the family dog. I don't do criminal law anymore. That was enough for me. Edit. Lots of people asking what happened should probably have put that in here originally. I'd left the firm by the time it actually got to trial, but was kept in the loop about the case by friends still there. He was found guilty and went off to prison. The defendant's main defense was that the daughter was lying to get him in trouble, and he could prove she was lying because he had a very distinct tattoo on his male body part, and she couldn't describe it. The daughter was on the stand testifying, and the defense attorney started down that line of questioning, and the daughter flat out said, "No, I can't describe it, because I never saw it, because every time he had his male body part out, he was putting it inside of me." Jury took about 10 minutes to convict. Edit. To clear things up a bit, this line was not the only one used to convict. There were other witness statements and reports that were used. Story 21. This came in a deposition, but it's still one of my funniest stories from this old job. I worked part-time as a paralegal when I was in college. We had this massive case with a lot of people involved that had spun out into a bunch of little side cases. In one of those side cases, this guy was claiming our client had left him threatening voicemails related to the main case, and him and his wife sued for loss of consortium. Loss of consortium, and I swear to you this is a real thing, basically means something happened that is stopping a married couple from having intimacy, and they want to sue you over it. The guy was claiming that he was so scared from these voicemails that he couldn't sleep with his wife anymore. Deposition time rolls around, and I'm sitting in the other room. But it's a small office and I can hear everything. My boss starts asking the wife how we're supposed to know that it was our client's fault they stopped having intimacy. Maybe she's just not as attracted to him anymore. Maybe he's not attracted to her. Maybe they didn't have that much of an intimacy life to begin with, etc. So this woman starts yelling, "I love intimacy," and banging her fists on the table. Her lawyers try to calm her down and tell her to stop talking, but she keeps on shouting, "I love intimacy." We used to have intimacy 2-3 times a day. We'd be thrown out of hotels because of the noise we'd make. And to the protestation of everyone in the room, her counsel and ours, she proceeded to describe their intimacy history in graphic detail, all of which was recorded in the deposition and filed with the court. Story 22. Former assistant state attorney prosecutor here. This defendant is called up for arraignment, and the judge is telling him that he's been charged with theft for stealing a roll of scratch off tickets from a gas station. The judge informs the defendant that since the value of the tickets was over $300, therefore it's a felony rather than a misdemeanor. The defendant says to the judge, "But Your Honor, to be fair, the tickets were all losers," implying it's not theft at all. I was amazed at the ingeniousness yet futility of the argument. Story 23. Traffic court speeding ticket. Your Honor, I didn't speed and I can prove it with logic. Judge. Okay. Lady. I drive a Prius. Judge. Lady. That proves I'm responsible, specifically in the realm of cars, so I obviously wouldn't speed. She had to pay the ticket. Story 24. Haha, I have a story for this one. I'm not a lawyer, nor could I talk at the time. During a custody battle between my grandparents and my mom and dad, who were addicts, the judge asks why my parents should have custody. Well, we are his parents. The judge says, well, you guys have substance abuse issues. No, we don't. So you're not using anything. No, we're both clean. When is the last time you've used? A few days ago, and we're done now. My grandparents won that day in court. This story has been told to me a few times by my grandfather. Story 25. Actual lawyer. What I dubbed the surprise party defense. In a hearing for an order of protection in which ex-wife is trying to get an order of protection against ex-husband who had been stalking her. They have a high school-age child together. Ex-husband tries to argue against the order of protection by saying they may need to be able to communicate about the child. The judge points out that they can communicate through the child, and also that other family members have been put in place by the juvenile court to be intermediaries for pickup, drop-off, etc. Then ex-husband has a brilliant light bulb idea. Judge, what if I need to throw my son a surprise party, and I need to keep it secret from everyone, but his mom still needs to know, so she doesn't throw a party the same day? In other words, while I admit have been stalking my ex-wife and that there are grounds to grant an order of protection, you should not grant that order just in case I need to throw a surprise party one day. What made it was how clever he thought the argument was. Thus was born the surprise party defense. Askreddit. A lot of you are upset about the comment of communicating through the child. That was probably a poor way to phrase it. In this situation, the father would be barred from passing messages to the mother through the child. He can't say, tell your mom X, but of course, some indirect communication is going to occur. And that is what the judge was referring to. In other words, the father cannot argue that he needs to be able to have direct communication with the mother for purposes of coordinating childcare. Things like that, which is often the issue. Because the child in this case is old enough to tell both parents, for example, about school, friends, trips, grades, etc. It is not as if the judge ordered the child to be the intermediary. That is ridiculous. Also, I sort of simplified the complexities of it because these people's parental arrangement was not the point. The dumbness of the argument was the point. But this is a criminal judge determining an order of protection. There is a whole separate juvenile family court judge that actually determines the custody arrangement and things of that nature. The bottom line is, the guy was trying to use the kid as an excuse to avoid an order of protection so he could continue to stalk and harass his ex-wife. Story 26. Several years ago, I was junior counsel in a prosecution in which the state alleged the 30-year-old male accused intimacy penetrated his 13-year-old foster daughter. Part of the state case relied on SMS messages allegedly sent by this gentleman to the complainant. Some of them were pretty bad, I won't repeat them, but there were some which amounted to, sorry, I thought you liked it when I did X. Defense counsel conceded that if he did send those messages, that it would have been very inappropriate. Later, during closing argument, defense counsel argued, surely it would have been more appropriate if he wrote, you have lovely breasts, or I want you to have my children. To your 13-year-old foster child, while in the same house you share with your wife? You're right, that's way better. Story 27. I'm a prosecutor now, but I used to have a private practice where I did a lot of evictions. My usual landlord clients wouldn't even come into my office until their tenants had been behind for months, and most of the time the tenants were defiant in their non-payment, so it wasn't difficult to not take pity on them. Anyway, one tenant was a particularly dumb guy. He usually came to court dressed in a wife beater and cut-off jeans. We had a trial date set and my client and I showed up. Tenant did not. At the last second before the judge entered a default, some woman comes bursting into the courtroom and yells, "Daryl's on the phone." The judge allows her to bring the phone up and we put tenant on speaker. He proceeds to ask the judge to delay the trial for 1 week because my brother got his head knocked inside out and is probably going to die. I didn't buy it, but my client knew Daryl well enough to sense the stress and fear in his voice. I told the judge that we would allow the continuance, but only until the next available court day. The judge set it for 1 week out. I still didn't believe Daryl until that night my grandfather was in an accident and we had to rush to the hospital. As we're walking up the hallway, I see Daryl in a room with a bunch of people who dress like him enough to obviously be family. When we get to my grandpa's room, he ended up being not as seriously injured as we originally feared. The first thing he says is, "You'll never guess what happened to the guy down the hall. Nurse told me his idiot brother dropped a tractor bucket on his head and opened it like a cracked egg. He's in a coma now." I relayed the news to my client, and she felt sorry enough for Daryl that we signed an agreement stating that he would clear out within 15 days and we would forgive all back rent owed. Story 28. This never made it to court. I asked my divorce lawyer what was the worst thing a client had asked him to argue. I was expecting a, I want the salad spinner sort of story. He had a client, a professor in his 70s, who was divorcing from his wife, also a professor in her 70s. They were both Jewish. His wife had a tattoo on her arm. It was a number put there by the Nazis when they put her in a concentration camp in WW2 as a child. Husband was born in the U.S., was not German. The German government was in the process of settling a case with the survivors. She had some amount of money, a six-figure sum due to her. The husband wanted his lawyer to argue that he should get half the settlement money. Lawyer told him that there was a special circle in hell for lawyers who asked for stuff like that, and that he was not planning on ending up there. Answer: I'm not a lawyer, and I think arguing over this kind of money is despicable, but I wouldn't be surprised if it was perfectly acceptable in Germany, where I live. Our laws are somewhat different, but the whole half of everything gained during the marriage thing is still alive and kicking around here. Maybe one could argue that the settlement money was actually gained prior to the marriage, when she survived the Holocaust, not when the money was issued during the marriage. Story 29. Wasn't the other lawyer, but his client. Took the stand in a retail theft trial. Claimed he didn't steal a couple salmon fillets on purpose. He was just so flustered by a phone conversation with his girlfriend that he accidentally slipped them into the pockets of his jacket. In a part of the store, the loss prevention officer called Shoplifter Alley because it's a blind spot for the cameras, and walked out without realizing it. It's not like it was a candy bar or something small. It was 2 salmon fillets. I asked him, "Have you ever done that before?" Him: "No." Me: "Have you ever seen anyone anywhere ever put fish like that in their pocket in your entire life?" Him: "No." Mercifully, the jury did not buy his ludicrous story and found him guilty. Story 30. I am a lawyer. Had a female inmate claim she was molested by one of the guards. One of her most darned pieces of testimony was testifying to this large vertical scar he had on his chest from a heart operation. She continued to say that she remembered this huge scar from when he molested her. The guard got on the stand, took his shirt off, and he had a tiny horizontal scar up on his shoulder. Case over. He had apparently told her one time that he had surgery, and she assumed it would have left his giant scar and used that to make up her story. Edit. To clarify, I was a new clerk for the judge when the trial started. I don't know exactly why this didn't come out in discovery. My guess, plaintiff's counsel were 2 years out of law school, appointed to the case, had only done corporate law, and were from a monster NYC firm, so probably didn't give it any time. As for the defense, either the Depth of Corrections wanted to publicly humiliate the inmate, people make a lot of dumb decisions based on a screw you mentality, or defense counsel wanted to get that trial money. Story 31. Also a lawyer. Had opposing counsel try to argue that because a landlady had written on her eviction notice, "It has been a pleasure getting to know you, but please leave," but had testified they were awful tenants that she disliked, that she was dishonest and nothing she said could be trusted, opened the question of dishonesty wide open. Although landlady wasn't an angel, tenants had an enormous string of fraud priors we could tell the court about as a result. Edit because of confusion around impeachability doors. This is UK law and relates to gateways for admissibility of bad character evidence. Answer: I have a trial coming up where it appears the defendant has forged documents. As in, I am 100% sure of this. Said defendant is going to get on the witness stand to authenticate these forged documents because nobody else can, and they are key to her defense. And this will allow the impeachment of her testimony with her past criminal history, which includes convictions and guilty pleas for fraud and forgery. Very curious as to how this plays out. Story 32. Not a lawyer, but when my mom was eliminated by a tipsy driver, we were filing a wrongful passing suit, and the lawyer for the defense used my mom's cancer to say that she was going to die anyways, so a wrongful passing dispensation was not owed. Story 33. Not a lawyer, but I do have a story for this. This happened while I was working as a medical assistant. One of our diabetic patients got a speeding ticket while his blood glucose was low, and he seemed to be under the impression that this would be an ironclad excuse to get him out of it. So he calls our office one day and I answer. PT will be the patient. Me. Dr. X's office, not his name if that wasn't obvious. The dark waffle speaking. How may I help you? T. Hello, TDW. I need the doctor to write a letter for me. Me. I can definitely help with that. We do this frequently, usually for a jury duty excuse or a note stating they need to bring their medications with them when they travel, etc. What is the letter for? I got a speeding ticket last weekend, and I'm going to contest it. I need a letter from the doctor stating that I have diabetes and that it impairs my ability to drive, so it wasn't my fault I was speeding. Me. Let me run through this with you, just so I'm clear what you're asking for. PT. Okay, me. You want a letter stating you have diabetes? T. Yes, me. And you want it to say your diabetes impairs your ability to drive? P. Yes, me. And you believe telling the judge that your diabetes impairs your ability to drive will get him to throw out the ticket? Yes, me. I don't think that's a good idea, sir. P. What? Why? Me. Even if they agree with your argument and toss out the ticket, which I doubt they will, if you tell them that you have a medical condition that impairs your driving ability, I'm pretty sure they'll take your license away. But no. See, I'm only impaired when my blood sugar is low. Me. Right, but this would go on for a few minutes before I told him I'd ask the doctor and see what he thinks. Unsurprisingly, the doctor agreed with me, said he would lose his license if he did that. So we didn't write the letter, but he still brought this argument to traffic court. The patient is now driven to his appointments by his family members. Story 34. Made a left turn on a green turn arrow. A city bus ran a red and T-boned me. My car was a little VW Rabbit, so it just scooted me, and I was perfectly fine. Driver pulls over, comes out and says, "The sun was in my eyes." I say, "I'm not hurt. Thanks for asking." Police arrive, and guess what? There was a literal busload full of witnesses. Everyone had the same story. She ran a red. City paid for my car, etc. She denied wrongdoing and went to court, which I had to attend along with a witness or two and the officer. Her defense? She had a migraine. Judge, so I should let you off the hook because you had a bad headache and was driving into the sun? Driver, yes, Your Honor, I'm glad you understand. She got her commercial vehicle license revoked. Should have just taken the points. Story 35. I wasn't a lawyer, but a law clerk working with the prosecutor's office. This guy was caught on the highest quality security cam video I've ever seen, stabbing a store clerk like 15 times. She survived, and then was tackled a block away from the scene, not 5 minutes later, by a man who had seen him flee and followed him, 25 feet from the knife and the jacket he'd been wearing that was covered in blood with a receipt with his name on it in the pocket. It was the literal definition of a slam dunk case. The guy chose to proceed to trial without his lawyer instead of having the case postponed after his attorney's house was broken into and all his files were stolen. This guy's main argument was that it wasn't him because in the statement of probable cause written by the officers after the incident, they misspelled his highly unique last name by adding a T in the middle, e.g. Johnson became Johnston. He spelled his name out at every opportunity with much emphasis. He also argued it couldn't be him because the man on the video tied a T-shirt around his head so that the distinctive tattoos there would be hidden, but he would never cover over his tattoos like that because he was proud of them and they represented his heritage as a Korean man. The jury took less than a half hour to return a guilty verdict. Story 36. Waiting for my case to be called, I heard a wild argument. It was a domestic violence case and the petitioner, person seeking protection, was accusing respondent, ex-boyfriend, of abuse. Specifically, he head-butted her. Respondent argued back by saying, "Seriously, honestly, judge, I couldn't have because look at my head, it's huge. A head this big would leave a mark? Honestly, judge, look at my head." To which the judge responded, "Son, I have a big head. Look at my head." This went on for a minute. Now, the story doesn't stop here. It just gets better. The respondent then argues that petitioner is keeping him from seeing their daughter and that she went as far as putting her uncle as the baby's father on the birth certificate. At this point, I look around with shock. The clerk's mind is slowly grasping what he said, and the judge nods his head with a typical Tuesday smirk. Story 37. I am a lawyer. Colleague argued that it wasn't animal cruelty to shoot a dog because the dog didn't suffer. This wasn't like a euthanasia situation, rather a robbery gone bad. The judge entertained it for a second and then came to her senses. Story 38. There is a famous case before the Danish High Court where a woman was violated by 8 bikers on a beach. The defense argued that she had wanted it because she willingly put herself into a situation where she was alone with 8 men. The female prosecutor then casually looked around, counted there was 11 men and she was the only female, and asked, "So, you are saying I am asking for it now?" The story says that was the only time all the judges have burst into laughter in any case. Safe to say the defense argument didn't go over very well with the judges. Story 39. I'm a lawyer. The most ridiculous argument I've seen was one I actually made. One of my clients got busted cooking meth. This was a very clear-cut case. They actually caught him in the middle of a cook. No way he was getting out of this one. Even worse, he was cooking at home and children were there. Yep, the DA loaded him up with felonies. There was no bail, and he was being held in the county jail. My client knew he was fudge. He had been planning to get married a few weeks after he got busted. My client asked me if he can get released for 24 hours so he can still get married. I tell him that I'll ask, but that there's no way in fudge hell they'll let him out. First, I ask the DA if they will allow it. Nope, they laugh, so I file a motion with the court. Now, I knew the judge was a crusty old conservative family values kind of guy, who also has a raging arousal for substances crime. There was no law involved, but I put together an argument about the sanctity of marriage and how the state should encourage marriage at all times, and that sort of thing. We have a hearing, and I make the argument. The DA is totally opposed and calls it ridiculous, and the judge grants it. The judge actually decided to allow my client out for 24 hours to get married. He had to surrender at the county jail at 8 a.m. the next day, and some other conditions, but still he was allowed out. Everyone is stunned. Nobody can believe it. The day of the wedding comes, my client gets out, gets married, then goes back to the jail. Everything went exactly like how it was supposed to, which is also pretty shocking. Story 40. Public defender checking in. Apart from the usual sociopaths who argue that there's nothing wrong with cheating people, stealing, and screwing people over, and apart from the constitutionalists who want me to argue that because they put their hands over their eyes, the government can't see them anymore, there were some good stories. I had a client accused of hit-and-run damage to unattended property, to wit, a stop sign post. My client had parked his car in front of a gas pump and walked into a Quickie Mart. The car rolled away from the pump without him, rolled over the curb, and then over a stop sign and into a ditch. My client ran out of the store, got in car, and promptly sped off. His driver's license was also suspended at the moment. This was all captured on video by a conveniently timed passing city bus. My guy wants me to argue that it wasn't hit and run because he wasn't driving the car when the thing got hit. He's got exactly half a point. I had to tell him that his argument solved, at most, half of the problem because it sure as hell was him driving for the run part of the hit and run. He took the plea deal. Story 41. Not a lawyer, but my uncle is. He had to defend a man accused of bestiality with a horse. Defense was that his male body part was too small to actually achieve climax in the horse's anus. Ergo, he didn't actually have intimacy with it. But I mean, he was giving it enemas with washing up liquid and even had a little stool to stand on when he was ready to go at it. So the defense didn't really work in his favor. Neither did the CCTV footage. Story 42. Not an attorney, but my grandfather told me a story about how he was into court in the early 1950s to defend himself for a traffic violation. The police officer used evidence against him that he had been rampaging all around town for the past few months, but the cop was such a nice guy he had been letting him go. My grandfather's response was, "Judge, I'm not sure about how much rampaging I've been doing, but it wasn't in your city. I've been helping to rebuild Germany for the past 18 months. I just got back in town on Friday." Story 43. My parents are both lawyers. Was in court with my dad when I was younger. Dad is throwing out objection after objection at the opposing counsel during cross-examination. Judge is sustaining all of them. Several hours into this, the judge is getting restless and asks the opposing counsel to hurry it up. Opposing counsel responds, "Well, if Mr. Surname would stop objecting, perhaps I could get through my examination." Judge did not like this. She lays into the guy. "If you would stop asking objectable questions, Mr. Surname wouldn't have to object. Hurry this, I'm not going to sit here all day." Was pretty cool to watch as a kid. Dude got roasted. Dad won that trial. Story 44. A taxi driver was charged with assault for pelting stone at a bus driver after a minor accident between both vehicles. Defense lawyer. "Your lordship, the bus driver was injured on right side of his neck. It is not possible for my client to cause that injury. The bus is right-hand drive, and the door on left side of the bus was open, and driver was in driver's seat." State. "Your lordship, is counsel unaware that buses have windows?" Defense. "The window was closed." Judge. "Really? How many times in this very hot and humid Indian city have you seen a bus drive around with windows closed unless it was raining?" Defense. "I request adjournment, your lordship." Story 45. I am a lawyer. The state tried to argue that probable cause exists simply because there is a police report alleging the crime. From the fact that a police officer filed this report, it is a reasonable inference that the crime took place as described. Good, allegations are self-proving now. Well, wrap up court then. I guess no need to hear any more motions to dismiss ever. I wonder why no other prosecutor in 240 years of jurisprudence ever thought of that before. 25-year-old assistant district attorney who went to the worst law school in this state. Answer, used to clerk for a federal judge. One clever inmate decided his motions for release were not working, so he filed an order for release with a letter directing the clerk to enter it. That didn't work. A different pissed sovereign citizen filed a judgment from his personal court against the judge. County clerk actually recorded it. Judge found out when he went to sell his house. Story 46. Not a lawyer, but I thought this was a very strange defense. Gary Heidnik had a history of mental illness, but nonetheless made a fortune in the stock market and had enough to retire indefinitely. In the late 80s, he decided to kidnap 5 women and chain them to the wall in the basement where he violated them every day, as well as tortured them. He was fond of electrocuting them for not getting pregnant. When one of the women starved to passing, he forced the other women to eat her body mixed with dog food. Another woman, when getting her routine electrocution torture, was accidentally electrocuted to passing. One of the remaining 3 victims asked if she could visit family if she promised to come back. He agreed and she called the police. In court, he claimed that he had committed no crime because the women were already chained in the basement when he moved in. Story 47. My dad told me a story in which his opponent claimed that the Surgeon General's 1964 warning was never released in the New York Times. He did this through use of a book, and he claimed the headline was not in there and did not exist. My father spent the entirety of the next night looking for the book, found it, bought it, found the headline for which he was looking, and absolutely demolished the argument the next day by showing the headline to everyone. Story 48. Currently studying law. One of my tutors told me about a case he had while working for the state where the defendant tried to claim that being an orphan had given him severe PTSD and mental illness and he was unfit to stand trial. Unfortunately, he was on trial for take down his parents, so it didn't really fly. Story 49. Not a lawyer, but was the child in a custody case between my parents. My mother's lawyer argued for and had put in the final agreement that I had to add my mother as a Facebook friend. Edit. This was 7 years ago. We are still not friends on Facebook, and she's blocked on everything I have an account for. Story 50. When I was clerking for a judge in my first year as a lawyer, we had a case that centered around if a person could lawfully shoot a dog that is attacking his chickens. The law said that he could shoot him if the dogs were bothering or wounding the chickens. Plaintiff was suing for the value of his dogs that were eliminate and emotional distress. His argument was that the dogs were not bothering or wounding the chickens because they were running away when the farmer came outside with the shotgun. He then argues that wounding has to be active. So he gave an example. If the dog has a chicken in his mouth, you can shoot. If he drops it, but the chicken is floundering right in front of him, you cannot shoot as the wounding has ended. Picks it back up, shoot the mutt, lightly paws at it, not wounding. It was ridiculous and inconsistent with case law. I wrote the opinion awarding defendant's summary judgment. Here comes my favorite part. Plaintiff asks for a reconsideration based on a single word I used in a throwaway line in the 8-page opinion. I said it was reasonable to assume that the dogs were still a danger to the chickens. During the reconsideration, the partner from the firm comes for plaintiff instead of Joe Schmo and says, "Frankly, Judge, I have always thought you were the finest attorney in the region, so I'm shocked you got this so wrong." It's baffling to me. Judge didn't react, but I was plenty offended on his behalf. So I am tasked with writing the reconsideration opinion. I wrote a 2-page summary of the hearing with no indication on the 2 pages which way we were leaning, then pasted the original 8 pages, but with the sentence about reasonableness omitted. I wish I could have watched that lawyer read 3 pages deep to realize it was the exact same decision as before. Story 51. Car accident case where the plaintiff was clearly trying to ham it up. Brought friends and family for backup, and the stories were all inconsistent. Cried on the stand. It was a small accident, and the plaintiff wanted a lot of money for sprains. The attorney said, "Yeah, there are inconsistencies and crazy stories, but you don't believe the person who tells you the same thing every time. That is the person pulling the wool over your eyes." No. Honest people are consistent. The attorney also had his client testify that no interpreters were used when they were, and that there was confusion about a question regarding a prior accident when that question was never asked. Edit. Am a lawyer. Answer. I was at fault in an accident once with the other individual being someone like that. I was second at a stoplight. Light turns green, we go. He slams his brakes and stops in the middle of the intersection. I rear-end him, but was at a reasonable enough distance to hit my brakes, and there was no real damage to either vehicle aside from minor scratches. I first get out of the car to make sure this other driver is okay. He steps out, hand on his neck, and before I get a word out, says, "Oh, it hurt, my neck. I need you write me a check." So I call 911 and we wait for the police. During our wait, another vehicle pulls up and a woman gets out and joins this man in his car. The third vehicle leaves. They told the police office that they had both been seriously injured in the collision. Thankfully, the officer was familiar with them and said he saw this all the time. He gave me a ticket for following too close, but told me I should contest it for the purpose of insurance, because he didn't believe there was anything wrong when they both declined an ambulance. Story 52. In child support, Your Honor, I already have 3 children that I pay for. I can't pay for a 4th. Are you the father of this 4th child? Yes, and I cannot afford her. I have 3 others. Ordered to pay full support for the 4th child to the surprise of no one. In spousal support, I'm an iron worker by trade, but I work in coals. Why don't you work as an iron worker? Certainly it pays more. They expect me to work weekends. That ain't happening. Ordered to pay full spousal support on an imputed income of an iron worker. In criminal court for harassment, I sent pictures of my testicles to her, XGF, to see if she thought one looked too big. It was medical, not harassment. What about the picture of your male body part? Same, I thought it looked weird, like I was sick. I needed advice. Is your XGF a medical professional? No. What is her profession? She's a kindergarten teacher. Turning your attention back to the pictures you texted, you said they were medical inquiries made to your kindergarten teacher XGF, correct? Yes. What about this photo with the caption, "Suck my male body part"? Was that also medical in nature? Story 53. I was involved in a trespass case where the defense argued the security supervisor of casino didn't have the legal authority to make somebody leave. They didn't argue the facts of the case, just questioned the supervisor on his own understanding of the trespass law and his powers as a member of the security department. Story 54. Defendant wanted to take back his guilty plea, arguing that the only reason he pled guilty was because he had to take a huge shoot at the time, but didn't want to do so at the courthouse. Another defendant argued that his was denied the effective assistance of counsel because his defense counsel permitted him to plead guilty to a DUI 20 years ago, after the guy crashed his car into a wall and was tipsy off his jerk at 5 a.m. in January. His defense was that he crashed his car, then in the 30 minutes, 1 hour waiting for the police, walked in the freezing cold to a liquor store, and drank a whole bottle of whiskey. And so he wasn't technically driving while intoxicated, but became intoxicated afterwards. The judge described the guy as either highly courageous or highly foolhardy for offering that story. Different defendant claimed his guilty plea was not knowing, intelligent, involuntary, and therefore invalid, because he was high as shoot-off cocaine and adult beverage when he came into the courthouse at 9 a.m. I've responded to countless motions from defendants who've said that they didn't know they'd be deported if they pled guilty, even though the judge explicitly told them exactly that. One defendant claimed that he couldn't have committed the robbery by climbing through the bathroom window because he has arthritis and knee and hip problems. He testified to this, despite knowing that we had security footage of him climbing in through a window of a church, also to rob it, then jumping up and climbing out, and despite knowing that the judge was going to allow us to show it to the jury if defendant opened the door to such evidence. Non-citizen defendant, who's a level 3, highest intimacy offender, argued that his designation should be removed because he was deported, and therefore he doesn't present a danger to the community anymore. Story 55. Slightly different, but worth noting. I recall off a Rob Dyke video that there was a guy arrested for multiple violation and the takedown of a young woman. He was sentenced, and in prison he injured himself to go to hospital. He then broke out, violation another woman, and took a family hostage before being arrested again. He tried for parole, and his claim followed the lines of this. Whilst the victim of the crime only has to suffer for a minute or an hour, the person who commits the crime has to suffer many, many years exiled from society. He got rejected 18 times and died before the 19th. Edit. Corrected spelling from parole to parole. Many thanks. Edit 2. Corrected spelling from exiled to exiled. Thanks again. Edit 3. Apparently the video I linked was incorrect in some of its content. Read this on link for more. Answer. Parole. That's crazy though. Not only is it silly, but does he really think that a violation survivor only suffers for the time they're being violation? That they just clean up and go about the rest of their lives unchanged? Anyway, I'm glad that there was justice for his victims. If violation is the first thing he does out of prison, he needed to stay in prison until passing. Story 56. In a child custody modification, I once had the respondent cite her arrest record as a defense against a claim my client had made. The arrest in question was for an aggravated assault charge in another state that we were not aware of. Later, the same woman refused to take a substances test because she had already paid her lawyer enough money before basically fleeing the courthouse. Needless to say, the children now permanently reside with my client. Edit, a word. Story 57. Lawyer here as well. Literally anything that the constitutionalists, pro-we, are you detaining me, sovereign citizens makes. This stuff goes back a long time. 20 years ago, I was getting the, they are impeding my freedom to travel, and now it's the, I'm a corporation arguments. I really wish people would stop believing that the law consists of magic words and incantations that lawyers have hidden from you. It isn't. They don't exist. You are driving us all nuts and you make the judges angry at you. Ridiculous argument I made. Client was arrested for failing to appear. She fell asleep under the trailer of a truck at a carnival she traveled with, and they drove off and left her there on the ground. Argument, Your Honor, she didn't miss court to disrespect the court. She's just stupid, right? You're not exactly the sharpest tool in the shed. Client sheepishly nods. Judge drops the charge. Story 58. Not a lawyer. Went to court to contest a traffic citation, and the cop didn't show up. Case dismissed. Thank you, Your Honor. Next case also dismissed. Guy stands up and is angry. Your Honor, I came down here to fight this. I brought my friend as a witness and everything. Judge, so you don't want me to dismiss this? I paid $15 in parking, and we came to fight this. Judge, do you want to take a moment to think this through? The witness has started tugging on the back of his buddy's shirt by then and talks him down. Thank you, Your Honor. I think I'll just go home. Story 59. Wasn't there myself. It was a video we watched in a trial class titled Worst Violation Defense Closing Argument. Can't find it on YouTube. Male attorney representing a man accused of violation stood in front of a mostly female jury. He dangled his wedding ring from a length of string, began to slowly jiggle the string, and then stabbed at the ring with his index finger to demonstrate how hard it is to penetrate an unconsenting woman. The argument was not convincing. Story 60. Not a lawyer because they don't exist. I got a ticket for expired parking meter, went in and contested it. The guy says, the parking authority took some pictures for evidence. How do you explain these? The pictures included my car, my license plate, and the parking meter, which clearly showed 13 minutes left on it. Answer. One time I got a ticket for parking my motorcycle in a non-parking zone, even though there was a giant sign above my bike which said, motorcycle parking only. When I went to contest the ticket, they looked at the photo the meter maid took, and sure as shoot, right above my bike is the sign. The woman rolled her eyes and said, Jesus Christ, these people are stupid sometimes. Story 61. A lawyer here. I sued the local sheriff in charge of running county jails here for not providing a voter registration application to inmates who request it. Instead, the sheriff had them fill out another form requesting both the application and a pen. His attorney initially argued that it's because the inmates don't have access to a pen. When I pointed out that a voter registration application can be filled out with a pencil, he changed his argument, saying that they don't have access to a pencil either. So I asked him, how do inmates fill out the request form for a pencil then? With their blood? He dropped that argument and settled. Story 62. In an aggravated assault case, there was a clear video from the Walmart parking lot of the defendant getting in the passenger side of a car, riding a little ways, and then hopping out to rob a guy, ultimately shot victim in the stomach. Police stopped the car soon after 911 was called, and the guys were arrested. The defense refused all offers for plea deals and went to trial based solely on the defense that the driver and passenger switched seats, with the car still moving, in the 10 seconds between him hopping in and hopping out. It was his third violent offense, and the defendant got life in prison. Story 63. So an important part of any legal case is that both sides be able to depose the other side's witnesses. This usually includes the plaintiff. My client was a very elderly woman who was hit by another car in a parking lot. She was not in good shape and had trouble getting around. Twice during the case, the other side scheduled a deposition. Twice during the case, my client showed up at our offices on time for the deposition, and both times the other side did not appear. They never informed us or our elderly disabled client, so she made the 30-minute trip to our office for nothing. At no point were any depositions canceled from us or our client. Those were the only two attempts made by the defendant. After the second time they canceled the deposition, they filed a motion in court to get our case dismissed on the grounds that they didn't have a sworn statement from our client yet. Again, this was entirely the defendant's fault, but they filed a motion to dismiss the case against our client. When asked at the motion why they canceled the second deposition, they even said that the attorney responsible had a personal conflict. Thankfully, the judge didn't even give it a second thought and denied their motion. Story 64. I'm a lawyer. I should win right there. Anyway, we were in trial, and opposing counsel was objecting to a document I was trying to enter into evidence through one of their witnesses. The witness had identified it as one of their business records, but opposing counsel objects. Jury is in the courtroom, so the judge has us approach. We do, and opposing counsel argues the authenticity of the document. I was a little surprised, so my response was, Your Honor, this is their exhibit. Is counsel stating they submitted inauthentic documents to this court? Judge turns to counsel. Are you submitting non-authentic documents? Opposing counsel stammers out a no, and the document goes in. I was a little surprised. They wanted to argue their own document wasn't authentic, just to keep me from getting it to the jury. Story 65. Longtime lurker, and maybe I'm only posting BC, this happened like a week ago, but whatever. First time for everything. The criminal defense attorney representing a guy who stabbed his wife several times and then beat her with a frying pan and then stabbed her again tried to argue that it is an affirmative defense to attempted takedown if you take your victim to the hospital after. He claimed it's impossible to attempt to take down somebody if you save her life after. He got bench slapped pretty hard, 1, for the horrible legal argument, and 2, for continuously saying this guy saved her life after he tried to eliminate her. Story 66. I am a lawyer. This was a petition rather than an in-court appearance when I was a pro se clerk. Pro se clerks handle petitions from prisoners. This was a state case, and the petitioner claimed that because our state awards good time credits for every 30 days you serve without problems, you get 10 days off of your sentence. For all sentences, even sentences of life, he had accumulated X years of credit against his sentence. Further, according to the actuarial tables, he would be dead in X years. Therefore, he was eligible for release. So far, this is a clever argument, even if it is bound to failure. What made it ridiculous was that he was not serving 1 life sentence, but 2 consecutive life sentences plus 20 years. Therefore, under his own analysis, he needed to serve more than his own lifespan before becoming eligible for release. As an added bonus, I dismissed his petition as lacking standing until he actually died, and we could properly calculate his sentence. Story 67. I was a state witness in a parental neglect trial. As an LCSW, I worked for a mental health substance abuse hospital evaluating children and teens for admission. The state was asking to have the kid removed from the home, in part due to information I reported as I had interviewed, admitted the kid on 3 separate occasions. During one eval, the mother shows up so high she can barely talk. The kid admits he gets all his substances from her. The other evidence comes from info gathered during the kid's inpatient stays. So this a very rural area with only 2 hospitals in the entire state. As such, I didn't work in the hospital, nor was I part of the inpatient staff. I lived 3 hours west of it, covering the 22 counties on the west side of the state. The prosecution had sworn statements and records from the inpatient staff and called me because I lived in the jurisdiction of this court and could testify in person. So all of this information was introduced the minute I took the stand. The defense lawyer basically repeats all of this and then proceeds to try get me to support his defense that the inpatient treatment was inadequate. How this relates to the mother giving the kid substances, no one ever figured out. He has absolutely no witnesses of his own, no character references, no other hospital staff, nothing but the state's evidence, and me. He repeatedly asked if I agree with his statements that X occurred in treatment or that if Y would have been a better option. After like the 6th time of me stating I was not able to answer the question, the judge cuts him off and asks if he has any other line of questioning. The mother whispers in his ear and he says yes, he has one more question. Do I think the mother is a fit parent? I was stunned. I looked around at everyone and asked him, are you asking me in my professional capacity if I think the mother is fit to parent? I see the state just kind of smiling and shaking his head. The defense is certain and says that's what he's asking. I look at the judge who smiles and nods at me to answer. So I say, no, in my professional opinion, she is not currently fit to parent. Everyone else is trying not to laugh, but the defense looks so disappointed, I almost felt sad for him. I don't know WTF they were thinking, but needless to say, the state won. Story 68. Probably late, this will get buried, etc., etc. Also not a lawyer, but my dad was, and this came directly from him. It's the late 70s, early in my old man's career. Client gets done for speeding. Ticket says 90 and a 55. Cop states that he assessed the speed by tailing client for over a mile before pulling him over. My dad, what kind of car do you drive? Cop, Crown Vic. We all have Crown Vics, Dad. And how high does the speedometer go in your Crown Vic? Cop, 85, Dad. So, how can you be sure my client was doing 90? Dismissed ticket, and the cop and my dad had a good laugh about it afterward. Cop said he'd never heard of a going too fast defense before. Story 69. Not mine, but my old mock trial instructor. And how do we know that witness's testimony is reliable? To witness, you need to wear glasses, correct? Yes. So doesn't that mean that you are legally considered to have impaired vision? Yes. Prosecution proceeds to build most of their cross-examination on this leg, painting the witness as unreliable because of poor vision. Finally, defense gets a chance to question again. You wear glasses, Mr. Witness. Is that correct? Yes. So whenever you're wearing glasses, you have 20/20 vision, correct? Yes. Thank you. No further questions. Story 70. Closing arguments. Disputed liability car accident trial. 11 white jurors. Black plaintiff and black defendant. Plaintiff had an eyewitness who was, for lack of a better term, ghetto. She had some credibility issues. Plaintiff's counsel in closing. She was just an eyewitness. She has no reason to lie. And believe me, if I could have picked a witness, I wouldn't pick one that looked like her. I'd pick one that looked like you and me. My jaw was on the floor. Jury was out 12 minutes. Defense verdict. Story 71. Damn it, this thread is 5 hours old and this comment will never see the light of day. But fudge it. This wasn't so much a bad argument, but an example of terrible questioning. This was a CERCLA case, cleanup of polluted groundwater and soil. A witness, a former manager of the polluted property, was asked the following at a deposition. Q. Did you ever see anything strange? At that point, a number of objections to the question were made by the attorneys present. A. What? Did I ever see anything strange is your question? Q. Yes, sir. Did you ever see anything strange? A. Yes. I saw a man with boobs. Q. You saw a man with boobs at the site? A. No. I saw a man with boobs in New Orleans once. Story 72. There was this defendant that was running a Ponzi scheme with a story about going into depleted mines and